and welcome everybody to another episode of the Trusted Trustee podcast. As usual, I'm joined by Tracey Besters to go through some of the issues with SMSFs. Hi, Tracey, how are you?
I'm good, Darin. How are you doing today?
I'm very well, thank you, and pumped for this episode of the podcast. And the podcast is brought to you by Super Fund Property Valuations, ATO compliance in a click. If your SMSF accountant or auditor is on your back for a property valuation, just order an affordable report from the experts with ease using the details on your screen now. And yes, the ATO is still talking about valuations and how they are focusing on them. So an extremely valued service that is, and you don't want to fall foul of those rules. Absolutely not.
Definitely not.
Anyway, we're continuing. Anybody who has been following this series of podcasts knows that in the recent series, we've been talking about estate planning issues and how important they are with what happens to your superannuation money if a member passes away. And so today we're actually going to talk about some of the landmark cases which have probably highlighted some of the issues that trustees really need to think about when they put together an estate plan. And I know some of the things that we talk about might actually seem a little bit trivial and flippant. They're definitely not, and they absolutely emphasize how important it is to, proverbially cross the T's and dot the I's with your strategy. So we're going to start by, and this is the landmark of all landmark cases, it's Katz versus Grossman. And this is a particularly nasty one, I suppose you could say, because this is actually a feuding brother and sister. And it didn't really turn out that well. So Trace, take us through what some of the facts were here. Not pleasant reading.
Yeah, no, it's not pleasant reading, Darin. And just before I do that, if you don't mind, I just want to make one, maybe 2 points actually, because my mind says one, but I'll probably say more than one. So I think that just taking one step back with SMSF planning for death benefits and, our demise, we're all going to happen one day to all of us. We often think, or there is a bit of a misnomer out there about your will covers your superannuation. And I know we mentioned this in a couple of episodes ago, but just to repeat the fact that your will does not automatically determine what's going to happen in the self-managed super fund. So if you want your SMSF money to go outside of the SMSF environment into your will or your estate outside of the SMSF, then you actually physically have to direct that to happen. It doesn't happen automatically. So over the years, I've had lots and lots of clients that I've spoken to about these estate planning issues where they've said, oh, it's fine, I've got a will. My estate plan is done. And I say, well, okay, that's great. Yes, you have got a will. Yes, part of your estate plan is done, but not all of it if we haven't then actually tied up what's going to happen in the SMSF. So I think that's just a nice reminder for, all of the listeners of the podcast today. And the second part about that is, leading into this kind of feuding stuff, we joke about normal families. And I don't think I've met too many people that say that they have a normal family. But if we have a look at the Katz versus Grossman case, it wasn't about a blended family. It was about a husband and wife who were members of the SMSF. The wife had passed away. The husband appointed his daughter as a trustee of the SMSF, and then, everything was all fine. The husband then passed away. The daughter is the trustee. She has a brother. She doesn't appoint her brother as the other trustee of the SMSF. She brings her husband into play. So she brings her husband in. So the daughter and husband have now got, control of this SMSF. And lo and behold, there was a binding death benefit nomination to the son. And a non-binding death benefit nomination. The father had done a non-binding death benefit nomination to the daughter and son, 50-50. She didn't honour that. So the daughter said, no, stuff you, brother. I'm not giving you any money. I'm taking it all myself. My husband is the trustee. And they actually went ahead and did that prior to all of the rest of the estate being sorted out. So the brother then said, well, I'm not very happy about that. My father wanted, me to have half, and took action against the daughter, and ultimately was successful. But at the same time, it's all of this issue about, well, what happens in what stage? And I think that's the crucial part. So
Yeah, and I mean that's your quintessential nuclear family there as well. And I suppose a couple of lessons there, aren't there? And as we always say, everything's sort of intertwined whenever you're talking about self-managed superannuation. But
yeah,
so not only was it a mistake to not make that death benefit nomination binding, but it was also a mistake, as it turned out, to only trust one of the siblings to be a part of the fund. Because if he'd made the son trustee, and I don't know what the circumstances were, maybe the son wasn't interested in being a trustee, could be that.
yes,
But it is important to know that, look, if you just favour one sibling over the other, as much as you think they can be trusted, you don't know
yeah,
what's going to go on down the track, especially when you're gone. They might tell
yeah,
you that when you're alive, but when you're gone, it might be a completely different thing, especially when another partner is involved. And in this case, the
take
son
it
was
and run.
excluded because he wasn't made a trustee. He trusted the daughter to do the right thing and made
Yeah,
her trustee when his wife died.
yeah,
But it didn't quite turn out the way that he would like it to have happened, and that's a
yeah.
real shame.
Absolutely, Darin. And I think, why did he only appoint the daughter as a trustee? Well, perhaps it was because they were individual trustees, and you only need two trustees if it's a sole member fund. If it's a sole member fund, there's two individual trustees. So certainly if he wanted to appoint his son as well, Mr. Katz wanted to appoint his son, then he would have needed to actually convert to a corporate trustee structure. So perhaps there was some resistance on his part to actually want to pay to have that corporate trustee structure set
Yeah.
up, because we hear that all the time, don't we?
Yes.
I don't want to have to pay for a company and why, all this kind of stuff. But this is such a great reminder, this case, and it's an old case, relatively old. In the SMSF world, it's old. But, this is a really great reminder that having the structure right for the control and the decision making is the most crucial part of your SMSF journey. You have to get this part right. You've got to think about all of the things that potentially could go wrong. And Mr. Katz obviously didn't think about the fact that his daughter Linda was going to run off with the money and, say, forget about my brother Daniel. That he wasn't obviously thinking about that. He thought, as you said, we can trust that the daughter's going to do the right thing. And sadly, when death and money is involved, we all know of stories in families where things like this go wrong. So how can you avoid it? Number one, the trustee structure has to be right. So having a corporate trustee in this environment, having both siblings directors of that corporate trustee, if required, that's going to, or alternate directors, whatever there needs to be, that's going to be one way. And making that non-binding death benefit nomination binding would have solved the situation here, and Daniel would have actually got some money.
Yeah, some really great lessons, and you don't want people to learn lessons the hard way.
You don't.
But in this case, this was a lesson that was unfortunately having to be learnt the hard way. But hopefully we can draw on this, and
Yeah.
any of you won't have to learn the hard way.
Not see a repeat of
We
it.
won't have to. Yeah, so no, exactly. We're gonna move on to Donovan versus Donovan, and that
Yeah.
again is about the issue of whether or not a death benefit is binding or not,
Yeah,
wasn't it?
yeah. It was again, Darin. Yeah, it was. And you kind of think, how can these little things cause such grief? Like how can we have such little things that, have this terrible outcome? So in the Donovan case, again, it was a sole member fund. The father passed away. This one had a corporate trustee, so it wasn't individual trustees, it was a corporate trustee. And the trust deed of this particular super fund, the Donovan Super Fund, whatever it was called, allowed for both binding and non-binding death benefit nominations, which is fairly standard. Like that's a fairly standard thing across the board. So Mr. Donovan made a death benefit nomination requesting payments to his legal personal representative. So he wanted to push it out of the SMSF environment into the estate. But the nomination didn't specifically state that it was binding. So it wasn't clear that it was actually a binding nomination. So the court actually held that it was non-binding because it wasn't obvious that it was binding. In accordance with the trustee. So what happened here was that basically the second wife of Mr. Donovan got all of the money, and it disentitled his daughter from his first marriage. So we've got the standard, blended family issue that we see goes wrong in this estate planning stuff. But if the non-binding nomination was held to be binding, it was going out to the estate, then the daughter probably could have had a claim on the estate. But because it was non-binding, the trustee of the SMSF was able to make that decision, and it wasn't able to change it. So the court held in this case that the deed was drafted in a manner that imported the requirements that a super fund must meet in order to qualify for those concessions. If the trustee, for example, says something crazy like the binding nomination has to be written in pink glitter pen, then we need to write our binding nomination in pink glitter pen. It's that specific sometimes with the trustee. So if we don't adhere to the facts of our trust deed, or we don't adhere to what the trust deed requires, remember that's part of the governing rules, then we can find ourselves in a situation where what we thought was binding is not going to be binding. And then it comes down to the trustees of the super fund making those decisions. So simple little thing, if you want it binding, it's got to be binding.
Well, it's funny, being part of the industry, we do talk about binding death benefit nominations all the time. And I suppose one of the comments that you did make there was, why would you not make a death benefit nomination binding? And I suppose this highlights another factor that obviously this is pretty complicated stuff. If you do it yourself, you really need to pay a lot of attention as to what's going on. But it also means that if you are seeking financial advice or legal advice, you have to go to a specialist, because if it's a generalist, perhaps the person could say, if you ask them, "Oh, do I have to make it binding?" No, we just do the nomination and we'll be okay. Not actually realizing, because he doesn't specialize in this area, what the significance of not making a death benefit nomination binding would be. And look, we're actually seeing cases right now of scamming behavior, I suppose you could say, or certainly bad actors in the sector, where they're actually offering financial advice. They claim it's a specialist. People set up an SMSF. They're channeled into a particular investment, and then it all goes pear-shaped. So it is really important. That is another thing, is if you are going to consult anybody on this, make sure it's specialized, because these things are really important.
Yeah, absolutely, Darin. And I think that you've got to make sure that part of the conversation that I have with clients around this estate planning is, who do you want your money to end up with? Can that person receive your superannuation benefits? Like, can they actually receive it? And then how do you make sure that step one is covered? How do you make sure that that's going to be the case? And there are some situations where you don't want a binding nomination. You want to have some discretion. For example, if the money was going to an adult child who was going through some business struggles, and potentially might end up bankrupt, then you may not want to force money into their hands via a binding nomination. Do you know what I mean? Like, you might actually want to take a step back and say, well, we might need some discretion here. However, all of the cases that we're seeing that are making, big waves in the space really are because the aggrieved party who thinks they should have ended up with some money is then trying to make sure they can attack the validity of those nominations in the first place. So if I can show that a binding nomination was invalid because it either didn't, because it didn't meet the requirements of my trust deed, or if the trust deed of that super fund, then I can show now that that's invalid. I'm actually maybe the trustee of the super fund, or I'm the person that, thought I should get some money, and under the binding nomination, I didn't get any. Well, I want to show it's invalid, don't I? Because I want to be able to, as the trustee of the super fund or the one controlling the purse strings, I want to pay the money to myself, or at least some of the money to myself. So if I'm the one that's, on the receipt of a binding death benefit nomination, I'm the beneficiary that's nominated there, and the trustee of the fund is not doing what should be done under the binding death benefit nomination, I want to show that it's valid, the binding death benefit nomination. So it all comes down to this validity of the documentation. And that's the Munro case. That's the next one we'll talk about. That's exactly the Munro case. Mr. Munro was a solicitor, and he still got it wrong, and this, I think, is a big, we kind of laugh about this case. It's a fairly old one as well, like 2010 or something like that. But he actually wrote the wrong wording on his binding death benefit nomination. He said he wanted it to go to his estate. So rather than write legal personal representative on the binding death benefit nomination form, he wrote the words trustee of deceased estate. And the court held that that wasn't a clear definition or description of his legal personal representative. So he's probably had too much knowledge as a lawyer to say, well, trustee of deceased estate is the same as a legal personal representative, but in this case, the court actually said, well, no, it's not the same. So wrong wording, just the wrong wording on a binding death benefit nomination. Donovan was that it wasn't binding. This one is that it was the wrong nomination. So therefore, there was no valid beneficiary nominated under that binding death benefit nomination form. Therefore, it becomes non-binding and therefore discretionary to the trustee. So just little things. It's not that we didn't have documentation in place to start with. It's that the documentation was held not to be the way we wanted it.
No, and it probably proves the point. I mean, we don't know what area of law
exactly
this person was practicing in. I'm sure he probably had some knowledge of wills and making a will and those sorts of details. But are you really well versed in how this is going to affect your superannuation fund? And it really does come down to that, because I mean, isn't this a classic case in point where, if it says you've got to write in a particular type of pen, then you've got to write in a particular type of pen. If you don't actually get the finer details right, you're really taking your chances if you're taking these situations to court, because you don't know how the court will rule on it. Why bother to take that risk?
100%.
The question you've got to ask yourself, why open yourself up to that risk? It doesn't make any sense whatsoever.
Yeah. And is it, sometimes is it that penny wise, pound foolish kind of saying? Is it that, we don't want to spend the money on proper advice? And I say proper loosely, because, most advisors and lawyers who are giving advice are giving proper advice. But is it because we don't want to spend the money on that specialist advice to start with, thinking that, we can fill out a form? How many SMSFs have been set up, Darin, over the years out of the 600,000 SMSFs where the binding death benefit nomination form has just been completed as part of the application forms of the SMSF? Oh, you've got to sign the trust deed. Oh, okay, here, now do this nomination form. There's lots of providers that actually provide a binding death benefit nomination form with the trustee documents. So, everything just can get signed. Great, efficient, but is it the most appropriate for that particular member of that particular SMSF? And what if it's not witnessed properly? And what if it's not this? And what if it's not that? Then you've signed this form thinking that you've actually got a binding death benefit nomination, and you haven't got a binding death benefit nomination. So really the trust deed comes down to be the crucial document here, doesn't it, to determine what needs to happen. And I had a situation years ago, Darin. It was a sole member fund, and he passed away, second marriage, and his son was the second individual trustee, so father-son. His trust deed was so old, it's the oldest one I'd ever seen. And his trust deed was so old and so deficient in terminology that it needed to have that under the little section of about estate planning, it said that the member must provide a written instruction to the trustee as to who the death benefit can be paid to. Failing that, it must go to the legal personal representative. The member of the SMSF, the father, died without a will.
Oh no.
So if he hasn't created a will, what are the chances, do you think, that he actually put some instruction to the trustees of the self-managed super fund as to his wishes? Pretty much none, because
Yes, I would say that.
no one could find even the back of an envelope instruction. No one could find anything. So then, of course, there was this big dispute, and it wasn't a dispute over who should get the money, because the children from the first marriage agreed that they would get the house, and that the wife from the second marriage would get the super. That was the most tax effective thing for the wife of the second marriage to have, was the superannuation benefits. But because of the wording of this trust deed, there was uncertainty as to who could she actually receive the money, because it did say very clearly in the trust deed, if you don't have this in writing, then the super death benefits must, the word must was there, must be paid to the legal personal representative. So that means the money's going to come out of the SMSF into the estate. Yes, it can go to the second wife, but she was not able to get the money back into super again.
Yeah.
So, we've had all this great amount of money, $1.6 million. We've had all of this money sitting inside super in a very tax effective environment that had to come out, be recycled to go back in. And she just wasn't able to, with her age, make the non-concessional contributions at the time to get it back in. So documentation is kind of really, really crucial. And this man actually was surprisingly an architect. So, he was very precise about certain parts of documentation in his life that, just didn't deal with this, didn't have a will and didn't deal with this. So kind of, not in one of the major cases, but certainly something I've dealt with firsthand.
No. And of course, these are not outcomes that you really would want to experience, especially when there's actually no challenge to the outcome. It's just whether or not the outcome can actually be executed, because you can't find the documentation to support, what the arrangement was. And it probably brings us to a good point to slip in a recent case. I know you've been saying that all of these cases are a little bit old, but there actually was a recent case. We've spoken about this issue in the past, where we're talking about how, and you just mentioned, the trust deed is the most important document to make sure that you can do whatever you want to do within your self-managed super fund, and estate planning is no different to that. And that is the Hill versus Zuda case. Now, it is often debated, and this has actually come up several times along the way, as to whether or not a binding death benefit nomination for an SMSF is non-lapsing, as in there's no time limit on it. The reason why this argument comes up all the time is because in the SIS legislation, it actually says binding death benefit nominations have an expiry date of 3 years, but then there's a carve out to say, except in the case of SMSFs. The only issue here is that if you put in your trust deed, we can do everything that the that the SIS legislation allows us to do, you're trapped. That means that clause of a 3-year lapsing period for a binding death benefit nomination applies to the SMSF. The Hill versus Zuda case was testing this again, and the court found that, yes, that exemption applies. If you're not subject to SIS legislation, it will not be a lapsing thing for an SMSF. So important to get these these minor details correct, isn't it, Tracey?
Yeah, absolutely, Darin. And you made the comment before that some of the things that we're talking about, particularly today, seem quite frivolous and quite, just these tiny little things, but they just have huge outcomes. And it's not hard to get it right. It's not hard to get an outcome that the member of the super fund wants to see happen, but you've got to go through all of the steps. You've got to, like you said before, cross your T's, dot your I's, schooling time's over, to make sure that you get this outcome. Because quite literally, if your self-managed super fund trustee says, in accordance with the SIS regulations or the SIS Act, you've got to do it in accordance with that. Like you said, you've got that lapsing situation that takes place. And I joke about, the pink glitter pen, but if your trustee did say that, and it said it had to be printed on yellow paper, and and I haven't never seen a trustee that says this, by the way, but just to make the point about how important it is, if you have a trustee that has really specific requirements, you must follow those. Now, it doesn't mean that you can't upgrade your trustee, of course, and that's often the most efficient way of correcting some of these things. Like in my situation with my architect SMSF case, they could have upgraded the trustee and it would have been easily fixed, but they didn't do that. They didn't spend the money to go ahead and upgrade the trustee. And if they ever did, no one could ever find it. So it had to be, held that it was not upgraded. But if you can upgrade the trustee, and I had a conversation with quite a in-depth debate with a guy years ago, Darin, about trustees. And, it was all around the concept of why do they have to be so complicated? Because no one ever reads them and no one ever understands them, really. And so he was like, can't we just have a few page trustee? And I think we've spoken about this before. Can't it just be cover page, signing page, and basically a statement that says do everything that the SIS rules allow? And your point is really valid with that in light of that conversation that I had with him, because what if the SIS rules say something more restrictive than what we can do? What if, like in that example, what if the SIS rules are silent on something, like how to commence the pension and how to do this and how to do that? Then we're in no man's land. And nobody wants to be in no man's land when it comes to having a decision that needs to be made by the court, when one of the reasons we have a self-managed super fund most likely is choice and control. So when we've done this choice and control conversation and then our decisions are taken outside of our hands because we haven't got the documentation right, then I don't know, just like does my head in.
Yeah, I know. And as usual, we start discussing estate planning, but all of these other issues intertwine. And if you don't get them right, they've got implications for something else that you may not think is associated with it. But then, unfortunately, you're going to find out badly in most cases that, oh, I didn't realize that would have these implications. And really, reviewing a trust deed is something that you should be doing all the time. And, things happen like this. The other thing that we don't always talk about either, I know we're talking about these court cases, and I know the court would be looking at it from a very professional viewpoint, and as we do, look at the face value of these cases and the lessons learned. When a member dies, it's a fairly traumatic time in all of these people's lives. It's not like, you can very coldly assess from a third person perspective as to how this should work or whatever. Finding out that the deceased wishes aren't going to be respected. I mean, how traumatic would that, not only obviously processing the loss of the person, but to have to go through this at that point in time. We don't talk about these things, but it is an absolutely valid point. Imagine contesting this stuff shortly after one of your loved members of the family has passed away. Who's in the right mind space to actually deal with this sort of stuff?
Yeah. And what tends to happen, you're absolutely right, Darin, and what tends to happen is it takes years. Years for these things to be sorted out. So you've got this whole grieving process. And, my father passed away very suddenly 4.5 years ago. He didn't have a will. So, it did cause some grief, pardon the pun. It caused them double grief really for our family because, there was just this unknown aspect of, we didn't have his wishes. He hadn't communicated those. He hadn't put together a will. Thankfully, he didn't have a self-managed super fund because that would have made things even more complicated. But, it is a really tough time to go through. And I think that if I can make it easier for my loved ones on my passing by having my documentation right and my wishes laid out and to make sure that what I want to see happen will happen, then I'm just taking that burden off those people. And the other thing, the last case that we wanted to talk about, I think the Worcester versus Morris case. That's a really good case on the fact that the executors of your will don't automatically just jump in as the trustee of the super fund. They don't just it doesn't automatic. Nothing happens automatically, except for a reversionary pension. Provided the documentation is right, yes. So that case, the Worcester Morris case, the father, the husband and the father, he actually basically, Mr. Morris, he had all his documentation right. He had his estate plan, his will was done. His daughters from his first marriage were appointed executors under that will. He had a binding death benefit nomination in favour of his daughters. He had ticked all the boxes, Darin, and it still didn't happen, right? Still didn't happen the way that he said. So as much as we say, well, have your documentation and all your ducks line up, sometimes there can be a party that doesn't want to adhere to that documentation. So sadly, Mr. Morris's second wife didn't follow the binding death benefit nomination. She changed the structure of the super fund to appoint a corporate trustee. She then put one of her family members in as the other director of that corporate trustee and claimed that the binding death benefit nomination wasn't executed properly and it wasn't delivered to her personally, so therefore it was invalid. And in this situation, the court, many years later, she'd actually passed away before judgment had been handed down. So it took many years for the daughters from the first marriage to basically get what was rightly, I guess, their inheritance from their father, who had done all of the right documentation, to have that happen. And it just took a long time for them to get that. So, that's a long time, a long drawn out time for you to have the whole situation sorted. And it's sad, really, to have these situations that come up, but hopefully they're a lesson for us.
Well, it's a real nightmare scenario. And of course, the longer it's drawn out, you can just imagine what sort of legal fees these people would be incurring. And of course, the more legal fees you incur, common sense would dictate that probably it's eating into the benefit that you're actually contesting at the time. So it's counterproductive from that situation as well. And it's just a situation that can really be I wouldn't say easily avoided, because if people want to challenge, they're going to challenge it anyway. But at least you make it watertight so that your wishes are actually what eventuates.
Yeah, exactly, Darin. And, I talk about with clients when it comes to asset protection, and I know we're not talking about asset protection, but when it comes to that, you want to put as many hurdles in place, right? So to protect everything, you want as many hurdles in place as you can to try and, I guess, not encourage people to, go after you. In estate planning, you want things to be as watertight as you can. And you hope that your executors, and you hope that the trustees of the SMSF are going to follow those documents, in the way that they need to be in order to avoid this unnecessary cost, and not emotional cost, as well as, physical costs and financial costs. And I have some very lovely friends who are lawyers, and yes, lawyers deserve to be paid. No one disputes that. Poor lawyers, we always say, who wants to pay more legal fees than you have to, poor lawyers. But anyway, we don't want to incur unnecessary costs.
Yeah, no, definitely. Well, don't worry. We've obviously filled your heads with some fairly distasteful scenarios here. So we'll draw a limit there so that we won't overburden you with some, situations that were fairly unsavory when we're talking about SMSF estate planning. So we'll sign off there. Thank you very much again, Tracey, for joining me today for this episode of the Trusted Trustee podcast.
My pleasure. It's nice to talk about this stuff in the sense of making everyone realize and understand that things can go wrong. And I'm really looking forward to talking about something more positive in the next episode.
Yeah, absolutely. Absolutely. I mean, death isn't a very positive subject to begin with, and then challenges of death benefits probably even less so. But thanks, Tracey. Thanks again to our sponsor, Super Fund Property Valuations. Thank you to my team for putting together these podcasts. Most importantly, thank you to you for joining us. We hope you've enjoyed listening to this podcast, viewing this podcast as much as we've enjoyed bringing it to you. And hopefully we've allowed you to glean some important information along the way. And as usual, the shout out is if you're enjoying our content on YouTube, don't forget to smash that like button and to subscribe to the channel. Other than that, thank you again, Tracey. Thank you for joining us. And we look forward to having you with us for the next episode of the Trusted Trustee podcast. Bye for now and have a great day.
Thank you.